Hello learners, I hope you people remember what all we studied in the previous lecture about contract law. So without further ado, let's begin with our today's lecture. So the first topic which we want to study is consideration. Now consideration means something in return, that is quid pro quo, which is an essential element to find out the genuine intention of the parties of the promise to create a legal relationship. Now, an agreement without consideration is void and thus not enforceable by law except under certain circumstances. Consideration is defined as when a desire of the promisor, the promise has done or abstained from doing, or does promises to do or abstain something. Such an act, absentee or the promise is called consideration for the promise. Now, an agreement must be supported by a lawful consideration on both sides. Let's study the types of considerations now. And the number one is your past consideration. Now, it means that the consideration for any promise was given earlier and the promise is made thereafter. For example, I request you to find my lost dog. Now, after you have done the same, if I promise to pay you ₹100 for that, it is the case of a past consideration. Under this, the Act recognizes only such consideration which has been given at the desire of the promiser rather than voluntarily. Next comes executed or present consideration. Now, when one of the parties to the contract has performed his part of the promise, which constitutes the consideration for the promise by the other side. In other words, consideration is provided simultaneously along with the making of the contract. The third one is executory or future consideration. Now, when one person makes a promise in exchange for the promise of the other side, the performance of the obligation by each side to be made sub-request to the making of the contract, the consideration is known as executory. For example, A agrees to supply certain goods to B and B agrees to pay for them on a future date. This is a case of executory consideration. Let's move further and understand that what are the essentials of a consideration. So consideration is to be given a desire of the promisor. Consideration is to be given by the promise or any other person. There should be some act, absentee or promise by the promisor which constitute a consideration for the promise. Consideration may be past, present or future. Agreement. Every promise and every set of promises forming the consideration for each other is an agreement. An agreement arises by an offer or proposal by one of the parties and the acceptance of such offer by the other. In other sense, it's an agreement. There is a promise from both sides. For example, a promise to deliver his watch to B, and in return B promises to pay a sum of ₹200 to A. There is said to be an agreement between A and B. That is, offer plus consideration is nothing but agreement. Now let's understand that what is a void agreement. An agreement not enforceable by law is said to be void. These agreements include an agreement without consideration, an agreement in restraint of trade, etc. Now, what are going to be the essentials of a valid contract? The first is offer and acceptance. There must be a lawful offer and a lawful acceptance. In other words, there are some legal rules governing others, offers and acceptances as well. Next is intention to create legal obligations. Both the parties to a contract must contemplate legal consequences. For example, A husband offering to his wife out for a movie is not an agreement intended to create a legal relation. Next is lawful consideration. Consideration is the price paid for the promise to the other. Consideration may be an act, abstinence, or a promise. It may be past, present, or future. Next come capacity of parties. Now the parties to an agreement must be competent to contract. That is, the parties must be major, mentally sound, and not be disqualified from contracting by law. Next comes your free consent. Now both parties to a contract must enter it out of their free will and consent. Consent is said to be free when it is not affected by the reasons such as cohesion, undue influence, fraud, misrepresentation, and mistake. Lawful object. The Act lays down that the object means purpose for which the agreement has been entered into must not be illegal or maybe immoral or opposed to public policy. Next is writing and registration. Now, it must be clearly understood that contracts need not necessarily be in writing. It may be oral or implied. However, the Indian Contract Act lays down that in certain special cases, for a contract to be valid, it must only be in writing. Besides, it also needs to be registered. For example, an agreement for the sale of immovable property must be in writing and registered. Next is your certainty. To ensure that a contract is valid, the terms of it must be very certain. In other words, agreements, the meaning of which is not certain or capable of being made certain, are void. For example, Mr. Sham agrees to sell his car to maybe say Mr. Mukesh at best competitive price. Now, since the price is not clearly ascertained in this case, the agreement is said to be what? Void. Next comes possibility of performance. The Contract Act lays down that agreement to do an impossible act is void. For example, someone agrees to bring a dead body alive in return for a crore of rupees. This agreement obviously is what? Non-enforceable. The last one is not expressly declared void. Now the Contract Act has expressly declared certain agreements to be void. For example, there are some cases like agreement is restraint of marriage, agreement is restraint of trade, agreement is absolute restraint of legal proceedings. Thus, an agreement should not be expressly declared void by the Act. Now, let's move on to another topic, that is acceptance. So, acceptance means when the person to whom the offer was made has given his assent to such offer. And Section 2B of the Contract Act talks about it. So, when the person to whom the proposal is made signifies his assent, the proposal is said to have been accepted. A proposal, when accepted, becomes a promise. It is only after the acceptance of the proposal that a contract between the two parties can arise. Now, what is going to be the effect of the acceptance? A contract comes into effect only after the offer is accepted. Before its acceptance, neither party is bound by it. Let's understand all of this by understanding what are going to be the essentials of a valid acceptance. So, acceptance must be communicated by the offerer to the offeree. Acceptance, in a sense, means making one's assent known to the offerer. That is, acceptance must reach the offerer and he must also be aware of it. That is, the offerer makes an offer and the offeree gives acceptance. So the offerer receives the acceptance and this is what your binding agreement. Suppose if Arvind makes an offer to Varun and Varun wants to accept it, he must ensure that Arvind is made aware of his assent by one way or the other. What if Varun assigns Rahul, a third party, that is, another person outside the two parties of the contract, to communicate his acceptance to whom? Arvind. What if that third party fails to do so? Legally, we say Varun's communication has the effect of being made to a third party and not to the offerer. Therefore, it fails the first rule. As such, the acceptance has not reached Arvind, so he will what? Not be liable to fulfill the offer to Varun. And between Varun and the third party, it's a different matter. There, the third party's liability will depend on the intention with which they had entered into the contract. Try to recall the portion about the legal intention behind an offerer from the previous article, such as, acceptance will not form what? An agreement. The next one is that the acceptance must be absolute and unqualified. So the law of contracts follows a no strings attached policy, that is acceptance. And acceptance cannot have any conditions attached to it. This is because acceptance is one's assent to an offer as it is. The condition null acceptance occurs commonly in what you're bargaining. Words and phrases such as but, if, in case are key to spot an acceptance with a condition attached. For example, let's suppose that X offers to pay ₹100 to whom? Y for a product, legally termed as what? Goods. Y can either accept ₹100 for the goods, name a different price, let's say by saying I agree to sell it to you but only at ₹120. In case it forms an agreement straight away. Or case 2 is that the part of Y's acceptance in his condition is not there, since he is not agreeing to sell it as per X's offer, but he agrees to sell it only at his what? Own price. In such a case, Y is making a counter offer which X is free to accept or reject, or even yet make his own counter offer. This counter offer functions just like any other offer and not as an acceptance of X original offer. This is just not going to bind X. So what is this? This is basically the concept of your counter offer. Next comes that the acceptance must be communicated in the prescribed manner or in a reasonable, usual manner. An offer may specifically mention that the acceptance is sent only by telegram and no other means. If any means is used, even though the acceptance will be communicated, it will not be a valid acceptance for failing the third rule. On the other hand, if an offer contains no such stipulation, then any usual mode of communication such as your telephone, email, telegram, fax, etc. may be used. For example, let's understand this with the help of an example. If a company makes an advertisement for the sales of its product, a buyer should contact the agent by phone or email instead of floating a large banner in front of the office expressing his intention to buy the product. Next comes your acceptance has to be communicated while the offer is subsisting. That is, if a date is mentioned as the deadline for the communicating your acceptance, that also makes up the terms and conditions of the offer. Failing that deadline not only bypasses a condition of the offer, but also the offer lapses or expires, that is, no longer exists. An offer must be revoked before an acceptance is communicated. This has the same effect and the offer ceases to subsist. Also, once an offer has been rejected or counter offer is made to the original offer, the original offer lapses. If the offeree decides to accept the original offer after that, the acceptance will be hit by this rule. But when is acceptance completed? Let's understand that. In case the parties to the contract are present at the same place, one making the offer and the other one that is communicating the acceptance, both the parties become bound immediately. Now the law has laid down the following rules when the communication of acceptance is done. That is, the communication of acceptance is completed as against the proposer when it is put in the course of transmission to him so as to be out of the power of the acceptor. And the communication of acceptance is complete as against the acceptor when it comes to the knowledge of the proposer. For example, B accepts A's proposal by a letter sent by the post. Now, the communication of the acceptance is complete only when, as A actually, when the letter is posted by A, and against B when the letter is actually received by A. So, when the letter is posted to A, and as against B, that when the letter is received by A actually. But what is revocation of the offer and acceptance? Now, a proposal may be revoked at any time before the communication of acceptance is completed as against the proposer, but not afterwards the acceptance. And what are its modes? By communication of notice, by lapse of time, by failure of acceptor to fulfill a condition, and by death of the proposer. Now, who are incompetent to actually, make a contract? So, a minor, that is a person below the age of 18 years, a person of unsound mind or insane, a person disqualified by law to the contract. But what are the exceptions? It's like natural love and affection, the compensation for past voluntary services, and the promise to pay time-bound debt. Now, in a very popular case, Mohiri Ghosh, that is ILR, I'm going to just write it down. That is ILR 1903. So 30 Cal 539. 539. Now, a minor mortgaged his house in a favor of money lender, alright, and received a certain amount from him. Now, the council held that money lender is not entitled to give the money back, which was advanced to whom? A minor. Now, this is because only a person capable of entering into agreement can make what? A contract. So, this is like a very, very famous case. But minor and the rules for estoppel, what are these? Let's understand this as well. So, a situation may arise when a minor has declared or intentionally caused or permitted another person to believe him to be a person who has attained the age of majority. Upon such belief, if the money lender advances some money to the minor, can the minor be held liable to pay? You need to tell me, is he liable to pay or not? Now, the Mohori case, which we just discussed, clearly ruled out that the rule for estoppels does not apply against a minor. It means that the minor cannot be held liable to repay a loan even if he has procured it by misrepresenting him as a major person. So the answer for this question, that is the minor liable to pay is no. Now let's understand the next topic, that is minor and the rule for restitution. Now again, a question arises as to the rule of the restitution applying against a minor. So restitution means to restore or return the benefit received by a minor under what? An agreement. A minor is not liable to restore the benefits received under a void contract except under certain cases. So a minor who has obtained money or goods by misrepresenting him to be a major can be compelled to restore the benefit to the extent he or his estate has benefited. If some benefit of permanent nature has been accrued to him, he has to restore them. So the example is going to be what? The example, if I want to make you understand, this is like, for example, a minor has to restore a car or a house purchased from a loan amount, but he cannot be, forced to repay any money used by him for temporary employment, for example, on eating or drinking or movies, etc. Or maybe like a minor meets an accident and a person expends money on his hospital expenses. He would be, like reimbursed from the minor's property. So like these are the examples if you want to understand that what is like minor and the rules for restitution. Next comes that what is a sound mind for proposing a contract. So we need to know that what exactly is a sound mind to propose an agreement. Now, a person is said to be of a sound mind for the purpose of making a contract if at the time when he makes it, he is capable of what? Understanding it and of forming a rational judgment as to its effect upon his interests. Now, a person who is usually of unsound mind, out occasionally of sound mind, may make a contract when he is of sound mind. And a person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of what? An unsound mind. For example, a patient in an asylum who is at intervals of sound mind may contract during the intervals, and a person who is delirious from fever or who is so drunk that he cannot understand the terms of a contract or form a rational judgments as to its effect and its interest cannot contract while such drunkenness lasts or any sort of thing lasts. So it was intense. I hope you people have understood a little bit about the contract law. We will cover the next portion in further lectures. Till then, you can go to EduRev and attempt the respective test to understand the chapter in depth. You can unlock all the logged videos, documents and tests for CLAT, and with EduRev Infinity Plan, ace your exams at less than 80 rupees per month. Thank you.